Retornando, então, agora para o quarto painel, Definição e Formas de Transposição. Compõe a mesa Dr. Marcos Vinícius Vita Ferreira, advogado e sócio da Blattness Advogados. E como expositores, doutora Ana Maria Belotto, advogada sócia na Madruga BTW. Doutora Rebeca Hill, sócia na Gatley Legal em Londres, virtualmente. Dr. Paul Smith, advogado na Hannes BVI. Dr. Tomislav Sunjica, advogado no Sunjica Advogados Associados na Sérvia, virtualmente. Para a condução desse painel, tem a palavra o doutor Marcos Vinícius Vita Ferreira.
Okay. Boa tarde a todos. Agora sim com o microfone ligado. É um prazer imenso estar aqui, mais uma vez, junto com o Instituto IBRA, que tem prestado um relevante serviço à comunidade jurídica em geral. O IBRA sempre em seus congressos trazendo temas e painelistas do mais alto gabarito, no sentido da cooperação internacional, já que o rastreamento de ativos é, sem dúvida alguma, um tema que perpassa a jurisdição brasileira e tem que necessariamente conversar e dialogar com as jurisdições internacionais, as principais delas. E, para nós, a Val de Advogados, mais uma vez se faz aqui presente pela importância desse seminário e, sobretudo, num painel como o de hoje, que vai tratar um tema tão importante e relevante para o direito brasileiro e para o direito internacional, que é o trust. O trust, que hoje talvez seja a principal ferramenta de proteção patrimonial, é um tema interessante porque passa pelo direito civil, comercial, desembocando no direito sucessório. Hoje, os profissionais de direito no Brasil, como no mundo, se valem desse instituto para proteger patrimônio e, sobretudo, para planejar suas respectivas sucessões. E nós temos aqui nesse painel, eu diria que o que tem de melhor nesse tema hoje no Brasil e no mundo, para poder explorar com a sapiência que lhes é peculiar esse tema, seja na vertente do direito inglês, das Ilhas Cayman e no direito brasileiro. E nesse sentido, então, sem mais delongas, eu passo a palavra por primeiro para a doutora Rebeca Home, que está online. Dr. Rebecca, it's a pleasure to have you here. Could you please explain us your experience with trust under the English common law and what the initial considerations when person fraud or bad actor claims against trust? It's a pleasure to have you here. Mr. Rebecca, you have 5 minutes for it. Thank you so much.
Thank you. Thank you for the introduction, Marcus. It's a pleasure and an honour to present to such an esteemed audience today alongside my So information about the trust is usually scarce. Trusts are private, and the underlying deed and other information about the trust is confidential. So generally, we'll have limited, if any, publicly available information. So in order to understand the routes available to obtain information about a trust, its settlors and its beneficiaries and assets, that will be key to any recovery strategy. I'm going to pass over to Paul, who's actually going to talk about the toolbox available to get information, which is pretty similar across most jurisdictions.
Okay, thanks a lot, Rebecca. Paul, now it's your time. If you can please bring us some information about the offshore jurisdiction established and what you might be attached to trust. Please.
Sure. Obrigado, Marcos. Boa tarde a todos. É grande prazer estar aqui no Brasil depois de 3 anos, depois da pandemia, especialmente nesta excelente e importante conferência. Obrigado ao Rodrigo pelo convite. Estou aprendendo, mas não estou pronto a continuar em português. Vou mudar em inglês. And I should say, I'm based in Cayman, so the comments I'm going to make today are based about finding information and attacking trusts in Cayman, but there are the similarities between the offshore jurisdictions and indeed England and Wales are probably greater than the differences. So for the audience today, I guess that the thing to bear in mind is that some of the things I'm going to talk about will be available in all of the jurisdictions, the offshore jurisdictions. I should also start by saying that not all trusts are bad. In the context of this conference, we're here to talk about wrongdoing and asset recovery and fraud. But there are obviously legitimate reasons for using trusts. It's a very ancient concept in English law and indeed in the law of the offshore jurisdictions. The Trusts Act in Cayman dates back to the 1960s. They're used for all sorts of reasons like succession planning and managing tax liabilities and protecting the interests of children and charitable giving, etc. But of course, that's not what we're talking about today. We're talking about the misuse, effectively, of trusts, because one of the things that they allow you to do, as Rebecca's already touched upon, is they provide confidentiality about ownership of assets. And that obviously is a great tool for bad actors to hide their ownership of assets. So moving on then to information gathering, how do you get the information that is going to help you form a claim? And I think in relation to the offshore jurisdictions, when we talk to onshore lawyers and the public generally, there is this perception that it's not possible to find out anything about companies or about structures in offshore jurisdictions. And that's true and not true. These days, actually, there is quite a lot of information that is available. So we also have judiciary in the Cayman Islands and in other offshore jurisdictions who are well used to cooperating with onshore lawyers and onshore courts to make orders to help uncover information that will support an investigation. So I'd say generally Cayman has a favourable climate, not just for scuba diving and beach holidays, but also for asset tracing. So the starting point is the publicly available information in Cayman. There's not a great deal of it, but there is some. So it's possible now to search for the current directors of Cayman companies. It's also possible to search the registers of aircraft and shipping vessels that are registered in Cayman, and Cayman is a jurisdiction that's used quite often for registering ships and aircraft, so that's potentially of interest. And we have UBO registers, the ultimate beneficial owner registers that we've been talking about in previous panels today. Cayman has had one in place since 2017. It's not publicly available. It has been available up until now to effectively to law enforcement agencies. But we will see how that develops because, as we said on a previous panel, there is this move towards introducing a much broader register, publicly available register of ultimate beneficial ownership. And I think Rebecca's going to come on to talk about that, so I won't say too much more about it, save to say that Cayman and I think BVI and other offshore jurisdictions will very much follow the UK's lead, and it's anticipated that things will change during the course of next year. So there may be more publicly available information come next year when we're carrying out investigations. So having exhausted your publicly available information, you're then looking at court orders to help you. And we're looking principally at what we common law lawyers refer to as the Norwich Pharmacal Order, named after the original case that established the jurisdiction. A disclosure order, effectively, requiring a third party to provide information that is necessary, that was the original test, necessary in order for you to have the missing piece of the puzzle that allows you to bring your claim. In the original case, the plaintiff knew all about the wrongdoing, they knew their causes of action, they knew what they wanted to achieve. The one piece of information they didn't have was the name of the proposed defendant. The scope of that has since been broadened to cover other categories of information, but it's an incredibly useful tool that we frankly use all the time. It's part of the bread and butter of the caseload of any offshore litigator. Will be doing lots of Norwich Pharmacal applications, and they're usually directed at service providers who provide services to companies registered in Cayman BVI, such as the registered office provider, because they are the people who keep the corporate records. Effectively, they keep the registers of shareholders and directors and mortgages and ultimate beneficial owner information. So with a court order, you're able to access quite a lot of information that you wouldn't otherwise be able to get. The other route to getting information, the other route via court order, is something that Nicosia covered on the panel just before lunch, the evidence, what we call the evidence order, letters of request, effectively. The piece of legislation in Cayman is called the Evidence Proceeding in Other Jurisdictions Order, 1978. There is an equivalent in BVI. There is an English equivalent in 1975, and what they're doing is incorporating into domestic law the Hague Convention of 1970 on taking evidence in foreign proceedings. And under that, you can get an order that is pretty broad. It's an order made following a request from the foreign court where there are proceedings on foot, already started, or contemplated, and the court can order quite a lot of things. Examination of witnesses, written or oral, production of documents, although you have to be quite specific. It's not a broad discovery power. It's we think there are these documents, we think they exist because, and then perhaps you might get an order for discovery of those documents, and orders for preservation of assets. So there are tools, they are often used. Relevance to trusts. How do you bring these tools to bear on a trust? As Rebecca said, one of the key advantages of trusts is the confidentiality. The deed is confidential. There's no real way to get at the trust itself, but the trust has assets, and very often in Cayman, the assets that will be held by the trust will be a shareholding in a Cayman company or a shareholding in a company elsewhere. So you can kind of find your way in to the trust that way. I have to say, though, in my experience, the battles I've had involving trusts, it hasn't usually been a question of trying to find out about the trust itself, because what usually happens is the defendant uses the trust as a defense. You come looking for assets, and you come looking to enforce against assets that you think are held by the defendant, and the defendant will say, not mine. They're held by a trust. I'm just the beneficiary, or I'm the settler of the trust. They're not really my assets. So when that happens, when you encounter a trust in that way, you're left trying to attack it, trying to find ways to attack it. If it's in the context of existing proceedings, one of the effective things to do is to use the civil procedural rules that we have in claims to push for very specific disclosure about the nature of the trust, how it came to be set up. And that's one of the ways that you can actually get your hands on trust deeds, because see, in the context of existing proceedings where one party is saying, these aren't my assets, you can't enforce against me, there is an expectation that they will be able to produce evidence to support that position, and then you can actually get the trust and start looking at it, start looking at the terms of it and trying to work out how to attack it. So that gets you into your lines of argument. And they basically fall into, I'd say, probably three broad categories of attack against a trust. The first is to say that the trust as a whole is a sham, that it's been deliberately created in order to give a false impression to third parties or to the court to say, yes, there are assets, but I don't own these assets. That is often quite a difficult thing to prove, because you find often with trusts that the trustee is sometimes it's a private individual, but more often than not these days it will be an independent third-party trust company, a service provider. And what you need to prove to attack a trust as a sham is that not just the settler of the trust, but also the trustee are involved in the deception, in creating the illusion that the assets are no longer held or controlled by the settler of the trust. And it's obviously very difficult to get evidence that proves that a trustee, particularly an independent trustee company, would risk its reputation and get involved in something like that. So attacks on trusts as sham do happen, but they're difficult to evidence in proceedings. The other ways to attack a trust are looking at the specific terms of the trust. Firstly, at what are called powers of revocation. Often a wrongdoer who is setting up a trust in an attempt to put the assets beyond the reach of creditors, beyond the reach of plaintiffs, they find it quite hard to give up control. You know, these are the assets that they've worked hard, they've defrauded hard to get their hands on these assets, and they don't want to just give them up, so they will keep powers under the trust deed that allow them to take decisions around how the assets are distributed, how they're invested, possibly powers to revoke the trust altogether. And in those circumstances, it is possible to get orders which attach to the power of revocation. I won't get into talking about receivers under common law, but effectively you appoint a receiver, a court-appointed officer who takes control of assets, usually physical assets, usually real property assets, but in this case, the right to revoke the trust has been held to be an asset in itself. You appoint the receiver, you take control of the power of revocation, you exercise the power of revocation, you get all of the assets out of the trust, back into the estate of your defendant, and then you're able to enforce against those assets because they're no longer protected by the trust itself. The other way to attack is a bit more difficult. It depends on the idea. It depends on looking at the classes of beneficiaries of the trust, the people who are potentially entitled to a distribution of assets from the trust. And in some cases, where you have only one beneficiary, and that's your debtor, that's your fraudster, then it's possible to form an argument that says, well, effectively that's a proprietary right, because who else is going to get these assets from the trust? It can only be this one person. I should caveat that by saying that the last case that tried this in Cayman failed, because on the terms of the particular trust that was being attacked in that case, the trustee's powers were entirely discretionary. There's quite a technical legal argument about this, and morally you can question whether it was the right decision that was reached, but what the court found was that it wasn't equivalent to proprietary right, because the beneficiary couldn't insist on being given the assets from the trust. Anyway, I think that one's open to argument. It will be interesting to see how Cayman Trust law develops on that, but it's a very unique set of circumstances, but it is a possibility. Yeah, that's all I was going to say for now.
Well, great. Well, I think we started with Rebecca with the London view of trust. Rebecca there is a partner of Gateway Legal with more than 30 years of experience in commercial litigation and international frauds. Now we heard about Cayman with Paul Smith. Paul also is the partner of Harness, and with a long experience in restructuring and bankruptcy. I think now we go to Serbia to see how trust works there in Serbia with Tomislav Sunjak. Mr. Tomislav is a lawyer and partner of Sunjak Attorneys at Law. Mr. Tomislav, now it's your time to tell us about how is the trust in Serbia and how the civil law works in Serbia with the trust protection and especially the trust risks in Serbia.
Apologies, Marcus, this is Rebecca. Do you want me to come back and speak about the position with regards to beneficial registers and things after Tomislav has spoken?
I think we go just write the Tomislav speech, okay?
Okay, perfect.
Good afternoon, everyone. Good evening. Do you hear me? Thank you, Marcus, for a short introduction. The main reason why I'm not here with you physically in Brasilia, in Brazil, is secondary most important thing on the world. This is football. Because when Rodrigo invited me to participate on this fantastic panel and especially fantastic event of IBRA conference, he said how cool will be that we watch World Cup football match Brazil and Serbia in November 24. And I started to imagine this cool situation that one Serb together with 220 million Brazil fellow watching the football match, how cool is it? And Rodrigo mentioned if Brazil win, you will be our guest entire night. And after that, the lawyer wake up inside of me and I started thinking, what will be if Serbia win? So I started thinking that if Serbia win, because I have no any enemy in Brazil, 220 million Brazilians will be my guest and I cannot afford it. Because of that, I decided to stay at home. Let's be a little bit serious and joke on the side. Who regulated foundations. Foundation is special entity very similar as a trust in common law system, because law was adopted in special procedure and was financed from US and USAID, and probably because of that influence we have some common law influence in new law and new regulation. We have two types of foundation. One is really something similar as a trust. This is foundation set up from the physical person or legal entities with some special individual goals and needs. And another kind of foundation, what is for, let's say, public and common purpose. When someone set up foundation in Serbia, this foundation is separate legal entity with separate assets, separate property. Immediately after formatting of foundation, all property what will be transferred to foundation will become property and assets of foundation. So individuals cannot anymore to be owner of that. They will lose the title. And one curiosity is when this trust will be liquidated, for instance, foundation liquidated in the future, this property never can go back to the individuals. So only new foundation can inherit this property. We have two parallel situations. One is how to extend liability of the trust to cover liability of individuals, and how to extend liability of the individuals to cover liability of the foundation. When we want to attack the assets of the foundation because some individuals are debtor, we have two main instruments. One is civil action, famous and known as Actio Pauliana, pretty famous instrument in civil law countries. So with Actio Pauliana, we always has a standing to attack third party, in our case foundation, if debtor transfer the assets to the foundation. This is first situation. Statute limit is 1 and 3 years, depends on some occasions and some elements. And second instrument is liability claim, famous Article 452 of the Commercial Code. This liability claim actually extend liability from individuals to the foundation till the value of the assets what was subject of transfer. So if asset has, for instance, 10 million value, if individual transfer assets to trust will be co-liable for the same value of the asset what was transferred, but will be liable with other assets of the foundation, not only concrete assets. So this is two extension of liability in one way. In another way, if individuals using assets of the foundation for the private purpose without any limitation, or if individuals abuse the assets of the foundation for the illegal purpose, they will be co-liable for the obligation of the foundation. So this is four situation what we have. With this, I will stop and I will be ready to continue with the UBO register once when Marcus you give me the word. Thank you.
Thank you so much. Rebecca, we will back to you for you make your explanation about the United Kingdom experience. Especially, Rebecca, are you hearing me?
I am, yes. Thank you.
Now I back to you for you to make a comparison with the English law, and if in the UK is the same position as the Cayman and as Serbia, please, you have now your time to explain wherever you want. Thank you so much.
Thank you. So the UK is similar to Cayman and is similar to other offshore jurisdictions that are English common law jurisdictions, which is not surprising because a lot of them get their original common law principles from the UK, and then they've put the overlay of their own statutory that Paul mentioned. Unfortunately, we've not evolved to the same degree as Cayman, so you may find England a little less generous, and indeed other offshore jurisdictions are a little less generous. Paul mentioned the increase in registers of trusts and beneficial owners. The UK tax authorities do maintain a trust registration service, and it requires certain trusts, which can include trusts that have an interest in UK real estate, to register. The information is not publicly accessible, but it can be accessed by someone who has a legitimate interest. And that means someone involved in investigating things like money laundering, terrorist activity, or if you can show the failure to disclose the information could prejudice a criminal investigation. So that might be advantageous to a prosecutor in Brazil who's pursuing a criminal action where there may be information held on that register, which could be very helpful. The English Companies House does have a register of ultimate beneficial owners of companies. Each company has one, unless the control is less than 25%. That is publicly available, but it's not stringently checked for accuracy. So depending on who's filed that information will depend on whether it's very helpful. However, with effect of August of this year, the UK has brought in an extension to overseas entities. So an overseas entity that owns UK property has to make an application to register itself and its beneficial owners at Companies House. And that has to be by 31st of January next year. And a restriction will be placed on every property owned by an overseas entity, preventing the sale of that property until that information is provided. And it has to update the information every 12 months. Trusts themselves don't have to be registered, but trustees of a trust with requisite control over a legal overseas entity holding property does. And the information, unlike what I've said for UK companies, does have to be verified by an independent, reliable source. And the government, UK government, have published a list of suggested agents who might verify that information. Certain information may be unavailable, such as the date of birth or the residential address information, and information about the underlying trust itself. So it remains to be seen how useful this will be and to what extent it might be used to cover UBOs of property in the UK, because of course it's not uncommon for offshore entities or fraudsters to have UK property. We have similar methods for attacking trusts. One of the things that has developed is the ability to trace. Now, tracing is not a claim, it relates to evidence. But the English courts have evolved when it comes to the requirements of tracing a claim. They recognize the world has become smaller and fraudsters or judgment debtors have become increasingly sophisticated when it comes to hiding assets. So traditionally, you trace each and every transaction in the chain from the original funds or asset to their ultimate destination. As we all know, bad actors or fraudsters will typically ensure that evidence is not available to do that. So in those cases, the court will draw inferences or can draw inferences in relation to the links in the transactional claim where the evidence is missing. Now, a lot of the cases have become much more complex, and a fraudster will create a complex structure of trusts and companies, and they'll also have a web of debits and credits back and forth between them, and they'll create a volume of transactions and a lack of information, and that makes tracing almost impossible, if not impossible. And it's referred in the cases, English cases, as cross-firing or creating a maelstrom, like a big black hole. What the English courts have said is it's entirely proper when that happens for the burden of proof to shift to the fraudster's trust or company to prove that what they're holding are not the traceable proceeds of fraud. I think I'll pause there in the interest of time, unless there's anything else that you'd like me to deal with, Marcus.
Okay, thank you so much. Well, now we go to Brazil. It's my pleasure to introduce, now in português, Ana Maria Belotto, uma advogada que nos enche de orgulho, sócia da Madruga BTW, responsável no escritório pela área de ética corporativa e compliance, escrita na New York Bar and Solicitor na Law Society of England and Wales. Ana, agora é hora de sabermos o trust no Brasil, os seus desafios e os seus riscos. A palavra é toda sua.
Obrigada, Marcos. Obrigada. É um prazer estar aqui nesse evento do IBRA, uns debates super interessantes e parabéns pela organização, tá indo muito legal. Bom, falar trust no Brasil já é uma contradição, né? Porque a gente está falando aqui de um instrumento que é naturalmente, como a gente vê a Rebecca e o Paul falarem, de países de common law. Então, a gente aqui num país de direito civil é um conceito muito diferente. Então, esse conceito de você ter essas três partes, né? O settler, o trustor e o trustee, e ter um interesse indireto num bem que fica ali meio sendo administrado, e eu acho que para o nosso conceito de quem é esse bem, eu acho que é muito difícil para a gente compreender. Existem até alguns instrumentos que podem ser parecidos, mas são muito limitados, às vezes é um testamento. Então, realmente é um conceito que no direito brasileiro ele é muito novo, mas ao mesmo tempo ele tem sim muitos efeitos no Brasil, porque os brasileiros podem, né, no exterior, e como o Paulo falou, não necessariamente o trust é uma coisa ruim ou ilegal, mas ela é um dispositivo disponível para todos. Então, a gente vê muitos casos de brasileiros que sim buscam, para fins lícitos ou ilícitos, essas estruturas no exterior, seja para proteção de seus bens, seja para ocultar os seus bens. A gente então vê aqui, a gente sente muitos efeitos desses trusts, e às vezes tomados de várias camadas, né? Então, um trust, uma pessoa jurídica, uma conta bancária no exterior, e por trás bens que às vezes estão sendo buscados, seja por entes privados, por razões privadas de busca de ativos, seja pelo Estado, por uma ação, ou seja, de polícia, ou às vezes até para fins de arrecadação de impostos. Então, quando você traz esses conceitos que são tão alienígenos ao direito brasileiro para o Brasil, a gente tem as dificuldades de, primeiro, como é que eu faço para encontrar esses bens? Então, eu posso ter uma ação correndo aqui no Brasil e eu preciso encontrar bens. E aí, como a gente viu aqui pelas explicações, são ações que até em países como o nosso são super difíceis de conseguir, porque é um conceito de confidencialidade, de não se saber de verdade quem está por trás desses trusts. E quando a gente vê aqui do Brasil, a gente tem muito menos mecanismos e precisa necessariamente do auxílio de jurisdições exteriores para poder ter qualquer mecanismo disponíveis. Tem casos bem famosos no Brasil. Eu, antes de estar no setor privado, trabalhei no Departamento de Recuperação de Ativos e Cooperação Jurídica Internacional do Ministério da Justiça. A gente trabalhava muito com esse conceito dos trusts e como é que a gente chega nesses bens. Então, o caso do Maluf, por exemplo, foi um caso muito famoso, em que tinha muita estrutura de trust, outras fundações, em que foi necessário, sim, a contratação de advogados no exterior para auxiliar, para encontrar esses ativos, e aí é como uma caça, né? Como o Paulo falou, às vezes você não consegue achar o trust diretamente, mas você acha os bens de um trust, e aí você vai atrás de tentar achar como é que você chega nesses bens. E mesmo quando essas informações chegam no Brasil, então, chegam, né? Então, usando aqui o caso do Maluf como exemplo, teve muita cooperação jurídica internacional com países estrangeiros, no caso Jersey, Inglaterra, Estados Unidos, e foi sim identificado quem estava por trás desses trusts. E quando essa informação chega, ela também vem cheia de conceitos difíceis para a gente traduzir também no direito brasileiro. Então, tem um caso muito recente, eu não sei se vocês acompanharam, em que essa questão do trust foi discutida em dois âmbitos até interessantes, porque são dois âmbitos fora do direito penal, que foi o caso do ex-deputado Eduardo Cunha. Então, ele como muitas pessoas que foram alvo da Lava Jato, várias informações vieram para o Brasil por meio de cooperação jurídica internacional, e no caso do Cunha foi numa ação penal, e essas informações foram compartilhadas com várias autoridades aqui no Brasil. E uma das autoridades foi a nossa Receita. E com base em informações desses trusts, a Receita buscou arrecadar pagamentos de imposto de renda desses bens que ele tinha no exterior. Isso foi uma decisão do CARF no final do ano passado, em novembro do ano passado, que foi discutido se existia realmente essa obrigação de você colher imposto de renda de uma pessoa física no Brasil com base em ganhos que ele teve de bens mantidos por meio de um trust em contas no exterior. Esse é o acórdão 2401-010-022 da segunda sessão do CARF. E eu acho que tem várias das discussões que a gente ouviu aqui, principalmente o Paulo falando de como você pode desconstituir um trust no exterior. A gente vê que no CARF se tocou em vários desses assuntos, e a defesa levantou várias questões de que não poderiam usar essas provas que vieram do exterior, o que o CARF derrubou, disse que vieram de maneira válida e foram compartilhadas de maneira válida, e depois ela fala, olha, mas esses bens, na verdade, não são meus bens, eu sou nada mais do que um beneficiário econômico disso, então não teria nem como declarar isso no Brasil como imposto de renda, não existe uma base jurídica legal que eu possa fazer essa declaração, e eu não sou o beneficiário aqui. Então, quando a gente ouve o Paulo falando de como essas defesas são trazidas em Cayman, é muito parecido do que foi colocado aqui, né? Essa estrutura, do jeito que ela acontece, eu não sou beneficiário, eu sou um beneficiário econômico, eu não sou o dono desses bens e eu nem teria como declarar isso. Então, existe uma ausência de uma obrigação legal aqui. Então, não caberia eu pagar esse imposto de renda. E eu acho bem interessante o que o CARF fez, porque ele fez essa análise, ele não entrou muito nessa análise se cabe ou não um beneficiário, mesmo que econômico, um trustee, declarar esses bens no Brasil para fins de imposto de renda, mas ele desconstituiu esse conceito desse trust. Ele fala, olha, esse trust aqui não é nada mais do que uma forma que vocês tiveram de ocultar esses bens, porque você misturou esses três conceitos, esses três papéis que a gente ouviu a Rebecca explicando, que então tem o settler, o trustor e o trustee, misturou tudo na sua pessoa, como o único beneficiário desse trust. Então, na verdade, isso aqui é uma ocultação, os bens são seus e você deve sim pagar esses impostos. Então, essa decisão foi bem interessante. E bem interessante também, por se tratar de um deputado, foi que isso também foi utilizado dentro da Câmara dos Deputados, pelo Comitê de Ética, como uma das formas de destituir o deputado do seu cargo. Então, foi dito que ele, na declaração dele, ele declarou que não tinha bens no exterior, e ele defendeu, realmente, eu não tenho bens no exterior, porque esses bens são desses trusts, do qual eu sou só um beneficiário, então eu não menti na minha declaração, e a Câmara, no caso, também tomou a mesma postura. Não, isso aqui nada mais é do que uma estrutura que foi criada para dissimular esses bens que estão no exterior. Então, tem sim bens no exterior, e houve aqui uma falha de decoro, e foi assim uma das razões que o Eduardo Cunha foi julgado na Câmara. Então, para a gente ver que, eu acho que esse caso é muito interessante, porque aqui no Brasil começa a julgar esses conceitos que não são nossos, mas que têm todos os efeitos aqui no Brasil, sem falar nas questões criminais, de lavagem de dinheiro, nas questões dos bancos, que tem toda essa obrigação de saber quem são seus beneficiários finais. Também tem questões práticas dessas estruturas tradicionais de common law, que são muito difíceis para a gente conseguir traduzir elas para os nossos conceitos no Brasil, mas que causam, sim, diversos efeitos na jurisdição brasileira. Então, essa é a minha contribuição.
Muitíssimo obrigado.
Obrigada.
Now we will go back to Tomislav. Tomislav, are you hearing us?
Yes, I hear you.
Tomislav, you have your time to talk something more about your experience and interest in Serbia and in the Balkans.
I would like to mention that we have law who regulate UBO, Central Electronic Register, for all entities, including the foundation, meaning trust, from 31st December 2018, and all entities has obligation to adopt own rules, internal rules, and to register the UBOs till last day, January 2020. And new entities now has 15 days after formatting, after setup, to register the UBOs. Who is the UBO according to Serbian law? The UBO is the persons and entities who has more than 25%. So at the end, we always must to come to the physical person who is UBO, or the individuals who has predominant influence, or the individuals who predominantly finance the entities and foundation, or the founders and individuals and manager of the property of the foundation, or representatives if they're actually enjoying the property of the foundation. And so this is the UBO, this is the individuals. And if you remember from my first part of the speech, that transfer of liability can be sent vice versa from foundation to the individuals. And this is individuals who can be co-liable and co-guarantor for obligation of the foundation. These individuals are entirely liable, so solidarily liable without any limitation. This is very, very important. And vice versa, when foundation is co-liable, is liable without any limitation and solidary liability. exists in the practice a lot of pro and cons of the UBO, because this is public electronic register, so everyone can have access to that register to check who is UBO behind someone. But some of the individuals who do not abuse the entities for the, let's say, illegal purpose or private purpose, who actually really acting in good faith, they are exposure to the criminals, because everybody can find out who is behind any entities, and family of them are exposure to for some risk. So this is pro and cons in the general situation. Marcus?
Yes, I'm hearing you. Hello?
I'm here. So I just finished this part, so it's up to you now. Should I continue with the case, some case exams, or should you transfer mic to somebody else?
Thank you so much. Paul, you have more. 5 minutes to say whatever you want.
I'm not going to subject everybody to 5 minutes, but maybe 2, just to mention one aspect of Cayman trust law, which is something you need to be aware of when you're attempting to attack a Cayman trust here in Brazil or in any other jurisdiction. Cayman, like a lot of offshore jurisdictions, has what we refer to as firewall legislation. Effectively, legislation that tries to protect a Cayman trust against an attack by a foreign court, usually in a civil jurisdiction where the concept of trusts isn't recognized or enforceable. And what it's found in Section 90 of the Cayman Islands Trusts Act. What it says, broadly speaking, paraphrasing a little, is all questions arising in regard to a trust governed by the laws of the Cayman Islands in regard to any dispositions of property or any aspect of the validity of the trust are to be determined according to the laws of the Cayman Islands, without reference to the laws of any other jurisdiction. So they're trying to build a protective wall around the concept of the Cayman Trust, so that in countries where there is no concept of a trust, or the laws on succession and inheritance don't recognize the kind of planning that is often part of a trust, that an order made by a court in those countries can't then be brought to Cayman and can't be used to unwind the trust. Now, this provision was probably over-relied on by Cayman lawyers, because it was seen for a long time as not merely dealing with the governing law that applies to a consideration of the trust, but also effectively as acting as an exclusive jurisdiction clause, effectively saying that if a foreign court has looked at the validity of a Cayman trust, we don't care. We're not going to enforce that order. It's irrelevant. It has to be a Cayman court that looks at it. We had a decision at the end of 2020 relating to a trust called the Stingray Trust that has unravelled that slightly and said, well, actually, that is not what the Act says. It's not what the intention of Parliament was when introducing the Act. All it is talking about is the governing law that a court has to apply when considering whether or not a Cayman trust is valid. And in the case of the Stingray Trust, what had happened was there was a challenge to the trust brought in Milan. And the trustee had gotten involved in those proceedings in Milan for a couple of years. And the court there had reached some conclusions about the validity of the trust. And the case came to the Cayman court for enforcement of that order, and the trustee was trying to say, well, no, that the Milan court is not entitled to look at this. And the Cayman court said, no, we've all been misreading the Act. That's not what it says. As long as the Milan court has applied Cayman law in deciding whether the trust is validly constituted, that's fine. You can enforce that order here in Cayman. And one of the problems that the trustee faced there was that they had gone and participated in the proceedings in Milan in this case. They'd submitted to the jurisdiction of that court. What you will often find now as a result of that case is that if you are trying to attack a case in a civil jurisdiction, the trustee of the Cayman Trust will go straight to the court in Cayman and start their own proceedings, trying to get an order from the Cayman court that will undermine the order that you're trying to get in in the civil law court. So it's just, I suppose it's a heads up, it's a warning. If you've got proceedings here in Brazil or in another civil law country where you're trying to say, there's no such thing as a trust, let's not, this is just a sham, be aware that if you're looking then to enforce the order that you get against assets that are ultimately held in Cayman or other offshore jurisdiction that has this firewall legislation, you may run up against this problem. If you can try to reel in the trustee to get them involved in actually participating in your proceedings to defend their position, that's probably going to help in practical terms. But also be aware that what they will probably do is try to start proceedings to undermine what you're doing. So it's just to be aware that this kind of legislation, this kind of protective legislation exists in the offshore jurisdictions.
Thank you so much. Bom, agora, como mediador, me surgiram várias perguntas. Achei que os temas foram muito bem explorados, as palestras estão extremamente ricas. Aí eu perguntaria aqui na nossa experiência brasileira, Ana, se você considera que a gente tem hoje ferramentas de cooperação internacional efetivas para que, uma vez detectado que o trust foi bolado, foi arquitetado para efetivamente desviar patrimônio, levando para o exterior ou para uma offshore, se no Brasil se nós chegamos a um nível de cooperação internacional que nos permita acessar canais competentes com outras jurisdições para que efetivamente a gente consiga recuperar ativos.
Eu diria assim, inicialmente que não, porque eu acho que o trust ele é um instrumento que ele é feito para ser sigiloso mesmo, essa é a ideia dele. Então, assim, é muito difícil, eu acho que, nos casos, acho que onde isso foi bem sucedido, foram muitos anos para chegar nisso. Os recursos são muito grandes. Acho que quando você está pensando na cooperação jurídica internacional do ponto de vista do Estado, então a gente está geralmente falando da cooperação em matéria penal, aí a gente tem o poder de polícia, né, que é sempre mais forte. Então tem o poder de polícia aqui no Brasil e tem o poder de polícia no exterior, para quebras de sigilos bancários, eventualmente quebras das estruturas corporativas e eventualmente até chegar nos trusts, como isso acontece. Mas isso eu vejo sucesso em casos muito grandes e em determinadas jurisdições. Claro que tem jurisdições, como os Estados Unidos, a Suíça, onde a cooperação entre o Brasil é muito grande e já tem até um conhecimento pessoal entre os policiais, entre as autoridades que estão atuando. Se a gente coloca isso na parte civil, ali, o privado que está tentando buscar, aí eu acho que é muito mais difícil e os recursos são muitos. Então, quando a gente ouve aqui da Rebecca, do Paul, do Stanislav, falando dos meios que você vê isso nos países deles, geralmente você está falando em contratar advogados privados que têm recursos e em ações, como a gente está vendo, que são ações muito complexas. Então, eu diria que conceitos de trust, eles, assim, na nossa experiência, quando eu estava no governo, eles raramente vem o trust sozinho. Então, você tem o trust, você tem a empresa offshore, você tem a conta offshore. Então, são estruturas quanto mais complexas, mais difíceis de você ir quebrando. Quando a gente vê, por exemplo, no caso da Lava Jato, a gente tinha pessoas que estavam se entregando a informação. E é sempre muito mais fácil, né, quando você tem o caminho das pedras. Mas essa investigação, por pura investigação, os casos onde foi bem sucedido realmente foram casos muito grandes e que demorou muito tempo para chegar nesse nível.
Obrigado. Acho que, e ainda nesse tópico, Rebecca, if you can please explain to us in 3 or 5 minutes how do you plan an asset recovery plan against a trust in UK, and what are the keys you consider at the outset to ensure are going to be able to maximize the recoveries? Rebecca?
Marcus,
Yes.
yeah, Marcus, thank you. I think a lot of it is practical common sense, and a lot of it, I think, we forget. When you're planning an asset recovery claim against a trust, just like any other entity, you need to work out what you're going to do. Are you going to go against the trust itself via the trustee? Are you going to target the assets? are you going to target the beneficiaries? And where are they all located? As Paul mentioned, there's firewall legislation in a lot of jurisdictions. Jersey has it as well. There's other jurisdictions that have it. So that means that, you know, if you are going to pursue the trustee, you're probably going to have to go in that jurisdiction. If you're going to go around the trust and you're going to target the assets, then it's looking at, you know, where are those assets located and how easy is it to realize them? And what's the cost of that? And you need to weigh that cost and that complexity against what you're likely to recover, because it's all about monetization. That's the most important consideration. So I think in terms of planning an asset recovery, I will sit and map this all out. And then once I've decided what jurisdictions are in play, I will engage the assistance of experts like my fellow panelists to have a brainstorming, a discussion about what is and isn't possible, how much it's going to cost, how long it's going to take, and to be realistically about what we might get back in terms of money. In terms of information, the same consideration. Is that information likely to unlock a pathway to recovery? So again, I would analyze that from the point of view of what return on investment. But the key takeaway for me is my team. So I'd want, you know, people like my panelists on my side working with me to make a recovery. Thank you.
Muitíssimo obrigado a todos, uma boa tarde e mais uma vez obrigado pelo convite.
Marcus, if I may, just a sec, if I may,
Sorry.
Marcus.
Of course.
I would like to finish as I started. So I would like the good luck for the Brazilian team on Thursday. Let's better to win. Unfortunately, I will not be with you guys. I will watch from my home. So let's see. And when we see each other, we'll be guest each other. It depends who will win. Thank you. Thank you all. Thank you for the invitation.
Senhoras e senhores, agradecemos a exposição dos painelistas e, em instantes, daremos sequência ao nosso encontro.